Good afternoon, everyone, and welcome. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. We do a community call every Thursday where we try to answer as many questions as we possibly can within the hour that we have. One Thursday, we do the call on our private bridge, which is this. And the second Thursday, we do it on LinkedIn as an audio call. You're all welcome to join. Remember, this call does not create an attorney-client relationship. Information is being given as is. I can't guarantee that what I got is right because there could be so many nuances and we only have this much time. But I do try to at least give you some guidance so you can investigate in a way that is efficient and proper. With that said, what I'm going to do is I'll first answer the questions that have been posted. They are posted on our forums, and this recording would be made available publicly. Each time I answer a question, I'll invite any follow-up questions on that issue and subject. If there are none, please wait till the end of the call to take new questions. And the way I would do it is, in about 20 minutes to half an hour, depending upon how many people have joined, I will close the conference. That way I can guarantee the people who are here will get answers to the questions that they have in the time that we have. Okay. So once again, I'll answer a question on the posted questions. If you have a follow-up, I'll ask for it. If not, we'll go on until it is time for me to close the conference, which could be anywhere from 20 minutes to 30 minutes from now, because if there are too many people, I won't be able to answer everyone's questions, right? So with that, let's get started. And it's good to have you all here. First posted question on our forums is from Liana, who says, I'm currently on L2 visa. Can I apply for I485? Priority date is not current? No, ma'am. You cannot apply for an I485 until your priority date is current. Okay. And of course, until you can get the, but you know, EAD, I don't understand. If you're on L2, you're automatically allowed to work. So your EAD question needs to be revisited. You should be allowed to work. And as far as travel document is concerned, unless you have an L2 visa, you will not be able to travel until 485 is filed and advanced parole is in your hands. Okay. Press *5 if you have a follow-up question on this, what I just discussed. Press *5 on your phone. Okay. Next question is from, I don't know who it is. Question number 3, B1, B2 application is pending. Can I apply for Form I-485 to adjust status? Can I apply for E2? Okay. Well, I don't know what you mean. I hope you are here in the call. Press *5 if you are here on the call, because there's a lot I don't understand about your situation. Are you on the call? Press *5? No. Okay. So 485 can be only filed if you are in a country that is not backlogged and you have some basis for applying for a green card. You can't file 485 just because you want to stay in the United States. There's a whole lot more here. Can I apply for an E2 if my B1, B2 is pending? And the answer is you can apply, but if on the date they decide your E2, B1, B2 is still pending, there is a very high likelihood they will approve the E1, E2 but make you go outside for visa stamping. Okay. And if B1 is rejected while E2 is pending, same result. You are not considered legal. I would not consider you legal. I would say you are accruing unlawful presence because you filed the E-visa while the B1, B2 was pending, not granted, and then it got denied. So the E1, E2 is not protecting you. How many months in advance should I apply for an E2? As early as possible. Do premium processing. That's what I would recommend. So I hope that answers your questions. *5. Press *5 if you have any follow-up question. No new questions, only follow-ups, please. Okay. Next question is, Brother's EB2-India 485 is pending. Dates retrogressed. Can my brother's wife apply for I-485? No. You cannot apply for a 485. Spouse cannot apply for a 485 if the dates are retrogressed. What documents are required at port of entry? So my brother's EP2 is pending 485. If he gets married, can his wife apply for I-485 along with his pending primary? Even if the date is retrogressed, the answer is not if the dates have retrogressed. How many months or weeks does it take for USCIS to give 485 adjudication? Whenever after the PD becomes current. Now, one thing you need to remember, guys, everybody here, if USCIS decides to conduct an interview for you for I-485, your green card process could have another 1 to 2 years added easily to your time. During the Trump era, just to make things difficult for everyone, they were trying to interview everyone. But during the Biden administration, they are not interviewing most employment-based cases. There are only two kinds of cases that are now being interviewed: random check, or there is something that needs investigation in your case. Okay. So the answer to the question, how long? It depends. If there's a local interview, a lot of time. If not, the reports of how much time they are taking are online. You can just Google or do a search on USCIS processing times. Okay. Let's see, what is the next question? Using EP2 I-485 pending based advanced parole to re-enter USA. Okay, that question is kind of difficult to understand. I'm assuming what you're asking me is, when I have advanced parole, what other documents do I need to enter? So yeah, of course, as you note, your advanced parole as well as your passport. That's pretty much all you need. Okay, I hope that helps. Star 5 if you have a follow-up question on what I discussed. Press star 5. No new questions at this time. Okay, let me zip through these questions. I'll probably be locking the conference for 5 to 10 minutes because we have enough people. I want to make sure I answer the questions of everybody who's logged in. On CPT and picked up for H1B 2324 lottery with approved 797, can I leave country for stamping? Okay, currently under CPT. Okay, I was able to get a visa stamp for November this year. Okay, I still have not graduated from my current program. Yeah, I think getting an H1B stamping should not be problematic. You could even try to go to a third country like Canada or Mexico, although there was some notification today that Mexico has some issues about third country processing right now. They may not be doing them. Double check, make sure if they are. You can try any of the countries around. You don't have to go all the way to India. You can try Jamaica, Costa Rica, Bahamas, New Virgin Islands, all these countries around us. Canada, of course, is taking a long time, but the other countries may not be. Okay. So can you go for H1B stamping? I think so. What I would want you to do, because you did CPT, just make sure that you have a consultation with a lawyer. Just talk to them and explain to them the situation. Let them look at your CPT circumstances, just to make sure there isn't anything here that could be a problem for your H1B. Normally, it should not be. Okay. I think I'm going to lock the conference, guys. We have a lot of people already here. Give me 1 second.
The conference is now locked.
Okay, so what I've done is I've locked the conference. After I'm finished answering these questions, I'm going to make sure that everybody who's here, their questions get answered, okay? So please be patient. All right, now can I leave the country for stamping? Okay, we got that. Now next question, Ramesh. I'm on L1B, approved I-140, priority date 2009 from my previous employer, who was acquired by my current employer in 2012. Okay, so there is a principle called successor in interest. Successor in interest. So the only way you would not have to refile the green card process all over again is if the new company acquired the old company in such a way that the new company becomes the successor in interest. That's a legal determination which should be made by your lawyers. If that is true, then your I-140 is approved. You directly apply. Well, you still have to do the I-140 again, but I guess you could try doing premium. While that I-140 is pending and your date is current, you can also file your 485. But you will not be able to file your, because even if there's a successor in interest, you have to go through another I-140 processing, but you don't have to do the PERM all over again. So important thing, action item, figure out if your lawyers believe that you are under successor in interest principles or doctrine, and file the I-140, and maybe you can file the 485 with it. Okay. Let's see. I've requested for Greek. Do I need to go through the PERM? Yeah, so I answered all those questions. Press *5 if you have a follow-up question. No new question, only follow-ups, please. Okay. Let's go to David. H-1B visa options to transfer, file amendment or extension. Okay. I have an H-1B visa issued in 2010 and I traveled twice after getting my, I'm assuming after getting your H-1B. Later, your H-1B was expired in 2014. You changed organizations in 2022. Is it possible to transfer H-1B? And the answer is yes. So if you want to know more about it, you can Google H-1B. I'm not saying Google, you can use any search engine. Google, Bing, Yahoo, whatever you want. But the term that you want to search for is H-1B remainder option. H-1B remainder option, which basically says if you have used X part of your H-1B 6 years, you can still get Y, which is remaining, Y being 6 years minus X. So whatever part you have used that you don't get back, you can use the remainder without having to go through the lottery again with any employer. And as far as I know, there is no time limit on this. Okay. So remainder option could be a good thing for you. Yeah. So you can do amendment and extension, Shija. That's the name written here. Okay. If you are here and you have a follow-up question or anyone has a follow-up question on this, press *5. Okay, no follow-ups. Next question is, we are right now on question number 8. I think I have about 15 questions to answer. Converted from H-1B, valid till September 25, to B1, valid till Jan 24. After losing my job. After B1 visa expires, can I apply for B1 again? Or do I need to change from H1 to B1? Travel options on B visa. So, okay. So first of all, do not let your B1 expire. Before the B1 expires, you can request another B1 extension. Okay. So while the B1 is still in hand and there's a few days remaining, apply for another B1 extension. Can you travel? Don't travel. That could be a problem for you. Okay. Let's see. I was working on H-1B, I-94, laid off, submitted 539. I'm able to find what are my options. Can I apply for B1 again? Yes, I already told you that. What form? Same form, I-539. I'll follow the same I-539. No, it won't be H-1B to B1. It'll be a B1 extension. Okay, I understand what you're asking. And what should I mention in the statement? Tell the truth that you are still looking for a job and you've not been able to find a job. Sometimes what I do is I provide statistics, employment statistics that show that it's difficult to find a job in the area that you are in and you're trying. So there could be some statistics published either by the state or the local government or the federal government. Look for those. *5 if you have a follow-up question on this. Okay. Area code 508. So that is Massachusetts. 1 second, sir. 1 second. My For some reason, oh yeah, here it is. Go ahead, please. I can hear you.
Oh, hello, Rajiv, sir. Thank you very much
Of
for
course.
supporting through all this phase.
Of course.
do have a follow-up question because my situation has changed a little bit.
Okay.
So this week, I actually found an employer who has offered me the job, and they have also started the LCA process as such.
Okay.
So right now, my B1 is already approved, which is till January 24, and they will be applying for the H1 transfer.
Mhm.
We will be applying in a premium basis. I
Great.
wanted to know, will it be a normal H1
Oh yeah.
transfer, or will
Oh
I
yeah.
have to go out
No,
first,
no,
get
no,
it
no.
stamped, and then start working?
You are good, because what happened was, when you are applying for the H1B, B1 is already approved. So you have status already. So you will get an H1B within the United States and should not have to travel out. Okay?
All right. Just one other question. So the joining date, like the tentative joining date they have provided is for November first week, which they have calculated based on how much time it takes for the H1 transfer on premium basis and things as such. So my mother is actually really sick right now in India. So I wanted to know, once maybe the H1 gets approved and everything, can I ask the organization to maybe deter my joining date by maybe a couple of weeks till I go back and visit my mother at home in India and then come back? Because there should be, I think, a running paycheck going on H1B. I'm not sure about that law.
Okay. So let me clarify 2-3 things for you. First of all, I'm very sorry to hear about your mother. It's very tough to have parents who are not doing well. Remember, you could even leave today if you wanted to. The only thing is, when the H1B is approved, the lawyer should send you a copy. You apply for a visa, H1B visa, and come back. Okay? So you can do that. Now, let's say you don't do that and you wait for the H1B approval. Can you take unpaid leave? Absolutely. Is the employer obliged to pay you while you're gone? No. Does that answer your questions?
Okay.
Okay. And when you come back,
unpaid leave is fine. Sure, please go ahead.
When you come back, make sure you bring some evidence of your mother's illness, because that way CBP knows that you are not. It's not like you don't have a job. It's because you had to leave due to the family emergency. And I would also carry a letter from the employer stating that we are waiting for him to rejoin. The job is open, and he has taken personal leave of absence. Something like that. And that way there's a good explanation for the CBP officer to sink their teeth into. Okay?
Okay. So should I ask the university for, the organizations, for an unpaid leave, or should I ask them to deter my joining date by a couple of weeks?
I think you can do both. Remember, when you are in the United States, you could go as much as 60 days for deterrence, or I should say deferral. But the smart thing to do would be to join so that you're on their payroll and then ask for unpaid leave. Okay?
All right.
But either one could
Thanks
work.
a lot, Rajiv, sir. You have guided me a lot.
You're welcome. Don't call me Rajiv, sir. Rajiv is fine. Okay?
Yeah. All right.
Good luck, sir.
Thank you very much.
All right.
Have a good day.
You too. Bye-bye. Okay. Yeah, I can call you sir or ma'am, but you can't call me sir. Makes me feel old. No, I'm just kidding. You can call me whatever the heck you please. So, Rehan is asking me about medical residency of his wife. So, I'm an engineer. My wife is a doctor, planning to come on H4, prepare for USMLEs. Can she do medical residency on USA on H4? Absolutely. But the problem is, and I'm assuming that you're talking about EAD, right? Because without EAD, she can't do a residency. Residency is a paid position. Okay. So assuming she has an H4 EAD, can she do a residency? I just dealt with this question, I think it was yesterday or day before yesterday. And I gave them the opinion that, look, residents are extremely important to the hospitals and to the organizations because they are the lifeblood of their clinical care. So I doubt very much any hospital is going to say, yeah, it's okay, you can start working on H4EAD and stay on H4EAD, because they want something more concrete than a visa and work authorization that is dependent upon the H-1B holder. So they may not like that. You can try. Can she do medical residency? Okay. Can she convert from H4 to H1B? Of course, she can convert to H1B if the job is exempt from the quota, and which many of these jobs are. What are the visa requirements for both? You understand, I just told you the bottom lines. If you are here, press *5 so I can understand what your other concerns are. These are pretty much the requirements. H4 EAD, then the hospital should be willing to accept that, or H1B or J1, of course. For H1B, you have to clear USMLE 1, 2, and 3. For J1, just 1 and 2. Okay. All right. Does anybody have a follow-up? Press *5. Okay. Marin says, working with 2 employers on OPT STEM, got picked up in second round of H1B with the first employer who did consular. Now concurrent filing for H1B. When can I add second employer as concurrent filing? Look, if you're trying to hide it from both employers, somewhere along the line, you'll get caught. And I just personally, I don't like concealing things from employers. What will happen is that when you apply for the second employer, your H1B papers will say it's a concurrent employment. So the second employer could say, hey, what's going on? Who is this other employer? Number 1. Number 2, if you apply for an extension, amendment, etc. for the first employer, there is a question there, I think, about all other H1Bs approved or the most recent H1B approved. So I think eventually they'll catch on. That's the way I see it. Now, if you do concurrent and both employers are okay with it, if I leave my first employer, does my second employer automatically become primary? Yes, that's the way it is. My second employer is cap exempt. Yeah, that shouldn't matter. So your situation remains the same. *5, if you have a follow-up question, press *5. Deepak, options for green card while in, all right, let's see. There's a follow-up question from area code 508, which is also Massachusetts. Boy, Massachusetts is popular today. Go ahead, Massachusetts, I can hear you.
Oh, hi. So this was my question, and the follow-up was that my second employer is okay with me having another employer, but the first employer is not okay. He's having a policy that does not allow me.
Yeah.
So what would you suggest?
Well, first thing, not from an immigration perspective, but from employment law perspective, I would want you to have a consultation with an employment lawyer in the state that you are working in.
Okay.
Because I don't want you to get sued for something. There are all kinds of things. Like in Virginia, we even have a lawsuit for something like a duty of loyalty. We can sue people even for disloyalty, which is a weird lawsuit. But you never know. So I would not want you to expose yourself to unnecessary legal liability. That's number 1. Number 2, like I said, somewhere along the line, it is possible and very likely that they will find out. For example, with the employer who's unwilling, if you ever did an extension or an amendment, the second filing would probably come, it'll probably be revealed. So I would not want to do it if I were you. Okay?
Okay.
Good
luck. I
luck.
think I will just leave the first.
Yeah.
Thank you for your suggestion.
You're welcome, sir. Bye-bye. Okay, now Deepak says, options for green card. Did I do the first? Yeah, I already did that one. So we are on question number 11 now, maybe another 4 to go. Options for green card while in USA on L1A. I-140 is approved. Options for L2S to L1A visa migration. Okay. So L2S means spouse of L1. So I'm working in the US on L1A. I-140 approved in April 23. PD is not current. Career move. Best options. My wife has her L1A blanket process initiated, hasn't completed DS-160 and visa. What would be the chances of getting AOS 485 completed in coming months? Nobody can predict the movement of priority dates. We all make guesses. So even actually the State Department makes guesses. Theirs are hopefully more educated than ours, so I can't really comment. What would be the recommended best path for me to pursue a career change? Well, I mean, if you want to do a career change right now, your green card will be out the window, but your priority date will survive. So that's your call. I don't have any recommendation beyond giving you information. You cannot change employers without having to redo the green card until I-485 is filed and has been pending 180 days. Is there a way my wife can complete her L2S to L1A with her employer and I apply for L1 to L2S without traveling outside of the US? Well, I don't see why not. So she is going into L1. She applies for change of status from L2 to L1. Now, in the same package, you apply for change of status from L1 to L2S. Yeah, I think it can be done. If I travel outside of the US, if travel outside cannot be avoided, can it be done in Canada, Mexico? Well, most countries will take third country nationals. I'm getting some vibes that Canada is having some issues. But like I said, you could go to any of the surrounding countries, Jamaica, Costa Rica, New Virgin Islands, Bahamas, and if you have a visa to Canada, Canada. So, but Canada is taking a long time. Check their times online. All consulates' times are published. Okay. So, if you have a follow-up question, please press *5. All right. Question number 12. Oh, there is a follow-up question. This is from New Jersey. New Jersey, go ahead. New Jersey. Hello.
Yeah. Hi, Rajiv. Thanks for providing.
Absolutely.
Hello.
Yes, sir.
Rajiv, am I audible?
Yes, you are.
Yeah. No, thanks a lot for answering those questions. I did have a few follow-up questions. So,
I can give you.
one was,
I can give you a minute or two. Hang on. We don't have a lot of time, so I can give you a minute or two. So prioritize your most important question, please.
Yes, sir. So the main one would be regarding the change of status for my wife from L2S to L1A, right? Which one would you recommend? So going for a L1A blanket, which means traveling outside the country, or if there is an option for pursuing the L1A individual, right?
You can do the individual.
Can that be done given her current status within the country?
Absolutely. Let the corporate lawyers help you decide what is best. Which method forward is best. But yes, certainly, even when you have a blanket approval for a company, we often do individual L1s, never a problem. Okay. Sir?
All right. And the second question, and maybe the last one, would be, so if she gets approved on the L1A, either as a blanket or individual, does that give me a ready option for L2S to move to in case leave the employer? Would that require a interview stamp?
No. If you do a change of status, L1, L2 should be able to be filed together. I don't see any problem with that. And if you decide to go for consular, both of you can go together and come back with L1, L2. Okay?
Okay. And this can be done separately as well, right? If we don't
it
go
can
to
be,
it together.
absolutely. The only thing is, remember, L1 has to be approved first. Then you can't do L2 before L1 is approved. Okay.
Right.
Good luck.
Right. Thank you so much, Rajiv. Yeah.
Bye bye. Okay. So, question number 12. Can I convert from H4 to J1 and get the 2-year return bond to country waived off? So I think you mean home residency requirement. And the answer is sure. But home residency requirements are not that easy to waive off. especially when it's a medical residency. Okay, so there is always a risk it could be a problem. Ideal situation is that you have passed USMLE 1, 2, and 3, and you can request the employer to process you for an H-1B visa rather than a J-1. Many hospitals may not be willing to do it, and many are. I personally know of people who've gotten H-1Bs from hospitals that said they will not do H-1B, but then they did it. Okay. Is it possible to waive off 2 years? Well, it is possible, but it's getting progressively difficult because there are so many applications. So there are doctors, physicians who have to go back to their home country because they were not able to waive off or get a waiver for the 212E home residency requirement. Okay. Star 5. If you have a follow-up question, press star 5. Number 13. Got picked up for H-1B, employer also filing L-1A blanket. So this is a situation where you want to keep the H-1B and you also want to keep the L-1. If I were you, what I would do is I would get the H-1B stamped first. Okay. And then go apply for L-1A. Either the consulate will cancel the H-1B, but you got it stamped. So that should exempt you from the lottery in the future. Okay. Or they will let it remain and just give you the L-1A, which is also okay. So my advice, get the H-1B stamped first. That will leave you the option of going to H-1B. You should not hold off on getting the H-1B stamped in my view. And there should be no complications for your green card. Press star 5. If you have a follow-up question, press star 5. Okay. Question number 14. H-1B renewal after a long gap with a pending court order. H-1B was issued in 2006, came to India, 2-3 years left on my visa. Can I renew my visa? I think you mean H-1B status. If another company is ready to file, yes. So do a web search for the words H-1B remainder option. Okay. So you got a court order from Labor Department for collection of money from the old employer, but the collection department was not able to collect. Can I file in court for collection after 10 years? You should certainly look into it. If it's a large enough sum of money, definitely worth looking into because it depends upon the local laws. Don't be deterred, but don't drag your feet. Get an opinion from a local litigator where the employer is located, so that you don't spend any more time waiting for things to happen. Okay. Press star 5 if you have a follow-up question. Press star 5. Okay. This is the last question coming up. Question number 15. Worked in US on H-1B and have approved I-140 in EB2 India. 2012 March priority date. Moved to Canada in 2017. 1 year left on H-1. What are my options to come back to the US on H-1B, continue my green card process? Employer asked for H-1B revocation and I-140 withdrawal. Okay. So if I came back with my previous employer consulting company, find a new contract, and if my date is current, does the employer have to refile the I-140? Yes, because they withdrew the old one. Absolutely, they have to refile. But you can continue from the I-140 stage forward. If I have to come through a new employer and restart, takes more than a year, do I still keep getting H-1B extensions? So yeah, the 485 has to be filed within 1 year of date becoming current. And the government has taken some very strict stances on this because we had been arguing all these years that if I'm not with that employer, how can I file the 485? And in one of not my cases, but somebody else's case that I looked at, government said, well, that's your problem. You have not filed within 1 year of the dates becoming current, and you have no valid reason for not filing, which is, I think, crazy. So be careful with this. I would argue that that job is no longer there. So what do you want me to do? How soon do I have to come back on H1 if my date becomes current? So you can even do consular processing 485 while remaining in Canada if you have a job offer. And if you are here on a visitor visa status, you should not change to H1. It's never a good idea in my opinion. Better to get a visa stamp and come back. If I get a contract, corp to corp job offer, do I have to wait for H1 approval? Yeah, you would. What documents do I need? You just need the H1B approval. If you're a Canadian citizen, you do not need a visa. Okay? Press star 5 if you have a follow-up question. Press star 5. Okay. So I guess this one is from Canada, Ontario. Yeah, Ontario, go ahead, please.
Hello, Rajiv. Thanks for taking my question. So I guess, my option would be if I come back with my previous employer, then hopefully I can just, within a year, get to I485, right? And let's say if that's not possible with my new employer, would L1, if they're okay with L1, I think I still get more than, I don't have that 1 year restriction anymore, right? And then with L1, can I still file for it?
Yeah. You should be able to because you're carrying your priority date from the old I-140.
Okay. And how about TN if the third option is, let's say, H1, L1?
Well, TN is okay if the government doesn't raise an objection against the pending green card, which they may or may not. TN is fine too, but it's a little trickier to time your TN to green card transition. Still, in your case, you have such an old priority date, you should be fine. Okay.
Okay, even if it's current, they probably would they ask if your priority date is current, but I'm not with the current employer.
For TN, there is no such question. For TN, the question is more, well, you want a non-immigrant visa, you have immigrant intent. That is a bigger problem. Okay.
Okay. And that would be if the priority date is current, or doesn't matter? Even
it doesn't matter.
140 states,
it doesn't matter. Not on a TN. It shouldn't matter. Okay.
Okay.
Good luck. All right. Anyone who has any question, press star 5. Let's deal with all questions. Anyone who has any question, press star 5. Okay, let's see. I've got 6 questions so far. 7 questions so far. So I'm going to go in 8 questions. Okay, 8 questions. All right. I'm going to go in the order that you guys joined the call. So let me start with area code 317. Just a second. Let me find you. Area code 317. Here you are. Okay. Area code 317. Go ahead. I can hear you.
Yes, Rajiv sir. Thank you. My question is regarding H1 and being laid off. So I got terminated on August 11, 2003. And currently I have a new employer. So the concern of the new employer is with the pay slip. Since my pay slips are bi-weekly generated, I don't have anything saying pay slip of August 11. Directly the pay slip says August 25. So, and since it is August 25, it says pay slip is retro pay slip, like it is paid for the previous one. So is it a problem?
I'm not sure I understand your question, but I can tell you this, that this is not a major issue. As long as you filed within the 60 days, this is all manageable, not a big deal at all. Okay.
Okay. If the employer is not willing, then what are my alternatives?
What do you mean the employer is not willing? What does that mean?
So this morning itself, I shared my pay slips with the employer. The employer is saying instead of August 25, which says retro, I will have to consider the July pay slip, which over limits my 60 days. So they are little skeptical about doing the filing. in that case?
Well, I can't answer that question. I have to. You may want to either do a consultation with us. Let me look at your pay stubs, or just talk to the lawyers who are representing you the H-1B. Let them help you out with this. I don't know if I can answer that question. What I would recommend is get your lawyer on the phone with your employer so that they can help explain the law to them. Okay?
Okay, perfect.
Good luck, sir.
Thank you.
You're welcome. Okay. So next one is going to be Illinois, which is 815. Hold on 1 second. Let me see where you are. Illinois 815. Okay, I can hear you now, Illinois. Go ahead, please.
Hi, Rajiv. My initial plan was to get married in February, but
Hello?
But for me, if it takes longer to get a...
Okay, hold on. I lost your voice for about 5 seconds. So go back from the very beginning. I'm not sure I followed it.
Yeah, it's a marriage-based green card question.
Okay.
My initial plan is to get married in February.
All right.
But considering the time, the green card EAD, the bride said she's okay to get married in November, but we will only be able to live since February. So, do you recommend getting married in February or in November to get the process started?
Okay. So I'm kind of I'm a little fuzzy about the details still. So your question is it allowed to get married in early? I mean, marriage is your right. You can get married anytime. I'm not sure I follow the hesitation. Yeah.
November, she would be able to stay with me only since February. We will be able to live together. But if it helps me in getting a green card EAD and not have any work gap, she said she's okay to get married in November. But initial plan was to get married in February.
Okay. So hold on, sir. Hold on. You said she'll be able to live with me only until February. Is that what you said?
Only starting February. We'll be able to live together.
Okay. So between November and February, because I was almost getting flashbacks of a mermaid. Somebody turns into a mermaid and is never seen again. Now that's what you're talking about, is that between November and February we will not be staying together. Is that right?
Yes, sir. If I'm getting married in November.
I see absolutely no problem with that. If there is a reason for it, for example, she's going to school or you have a job and there's a reason you have to stay apart, between November and February, even though we got married in November. Absolutely okay. I don't see any problem with it.
Got you. So, sir, Rajiv, do you recommend getting married in February or in November so that my visa expires in December 2024?
No, get married as early as possible simply because it will put you in queue for the EAD early. My only focus is the EAD. So do that. Okay?
Perfect. Thank you so much.
You're welcome. You're welcome. Let's go to area code 309. Yeah, 309. Go ahead, please. Oh, I think I just did.
Yeah, hi, Rajiv.
Oh, okay. Yeah. Go ahead, sir.
Are you able to hear me?
Yes, I can. Go ahead, please.
Yeah. Thank you in advance for taking my questions.
My
I just wanted to understand about LCA, which was approved on a yearly income basis. Like, can we get more than the amount mentioned in that approved LCA?
Oh, absolutely. But only if you split 50-50 with your lawyers. I am joking, sir.
I didn't.
I am just kidding. So remember, under H-1B regulations, let's say I had a case a few years ago of an investment banker whose LCA salary was 72,000, but his bonus was 600,000. Okay.
Wow.
Can you do that? Sure, that's perfectly legal. You can always get paid more. You cannot get paid less. Got it?
Okay, even though if it is not a bonus, even though if it is a regular.
Even if it is a regular raise. The only time I worry is if you had a $70,000 base salary and then the employer said, okay, your base salary now is $670,000. Wouldn't that be nice? Okay, so $670,000. Now I have to look at the case and say, should I do an H-1B amendment? Is the salary not so large that the government should look at this case again? I probably would. But if it is just 5-10% over what you were getting paid, I would not worry about. Up to 10%, I wouldn't worry about it.
Okay.
Okay. But
and
if
this won't.
Yeah. No, I see no problem with that. Personally, I don't. You can talk to your lawyers, but if we were representing you, that's what I would tell you. Don't worry about it. It's fine. The job description should not change. If the job description has changed, then we need to do an amendment. Okay?
Yeah, okay. Job description was not changed.
Yeah,
like amount got increased a little bit, so yeah, that's why I.
Oh, little bit is okay.
skeptical
Little bit you don't need to worry about little bit. That's fine.
Okay. Yeah. I mean, talking about like 20 to 30K difference.
On a salary of how much?
100K.
Yeah, so that's about 20%, 30%. Your lawyer should take a look at it because that's more than 10%. Okay. So 10% is not a rule. It's just my own guess. 20-30%, why not do an amendment? It's easy enough. What's the problem?
Okay. Yeah.
Okay. Good luck.
Yeah.
All right.
Thank you.
You're welcome. Let's go to area code 872, which is also Illinois. Illinois, go ahead, please. Illinois.
Yeah. I'm there, sir. How are you? Yeah.
Good. Yes.
Sir, I entered US with H1 in 2023 March, sir.
Mm-hmm.
And I stayed till September because I got Canadian open work permit when I applied it.
Mm-hmm.
So I entered Canada, Toronto now.
Mm-hmm.
But I have my I-797 valid for 3 years.
Okay.
With my US consultant or employer.
Okay.
So in this case, I was just confused. I came to Canada for a new opportunity and I'm trying for my jobs.
Okay.
But what if I don't get an opportunity in Canada? Can I still come back to US is my question, sir.
Okay. So you don't have a visa stamp yet, right?
I have a visa stamp. I stayed in US for 6 months, close to 6 months.
So, okay.
I came to Canada on an open work permit.
Okay.
And
I got it. So the answer to your question is theoretically, absolutely no problem. Theoretically. As long as your employer can provide you a letter truthfully explaining that the job is still available for you. I had a guy join an H-1B over a year after the approval. Why? Because we have a company in USA, we have a company in India. He was finishing up his project in India, but the job was still available in US. As long as the job continues to be available, I don't see any problem.
Okay, so you mean to say the employer has to give me the letter now itself, or
no? When you want to come, at that point they should give you a letter. Because if the Customs and Border Protection wants to question you, hey, what happened here? Why are you coming, after so many months? The answer is, well, because I went to Canada. Always be truthful. I wanted to look for a job. I couldn't find something that I liked, or I couldn't find a job. My old employer is still keeping the job open. They want me to come back. I am good to go.
Okay, in that case, what is the status of mine where the employer has to keep, sir? Till that time? Because now they will not run my payroll, right? So should they keep me on hold, or what is it legally?
Well, the way I would do it, if I were advising the employer, I would probably tell them to revoke the H-1B. Okay. And I would, because if your entry is not certain, it is better for them to revoke and then refile the H-1B when you're ready to come back. That makes things even easier. Then you don't even need a letter, etc.
Okay. Okay. So in that case, I have to reapply for a visa and
No. You can use the same visa.
Okay.
Okay.
I can use the same visa
Yes,
which
sir.
I have for 3 years.
Absolutely.
Okay.
Absolutely.
And re-enter.
Absolutely.
Okay. Till that time, they can revoke.
Yep. Absolutely.
Oh yeah. Got
Okay.
it. Got it. Thank you so much.
You're welcome. Good
Yeah,
luck.
Thank you so much.
You're
Have a
welcome.
great day.
You too.
Yeah. Yeah.
Okay. So next one is area code 508. 508 is from Massachusetts. I'm very popular in Massachusetts today. Yeah. 508, go ahead, please. We can hear you.
Yes. Hi, Rajiv. This is Kartika here. So I had question regarding my H1. So basically, I mean, I got laid off, and then I had another employer who did my H1 transfer in July 18th. So the petition basically reached on July 18th, and it's still not approved. Now, if I find another employer, will they be able to do my H1 transfer without it being approved, the previous one?
Okay, so let me understand this. Are there 3 employers in the picture?
No, 2.
But you have a...
So right now there is one. I mean, yeah, it could be 3 actually, because one...
So you left one. You left one.
Yeah.
You are waiting for 2 to be approved, and you want 3rd to apply.
Yes.
Okay. So first of all, people here hate you because you have so many jobs. We don't like you. Okay. No, I'm just kidding.
No, I don't. I don't have so many jobs. Like the first one approved, got laid off, and
no. You must be. You must be very talented, Kartika. That's why everybody wants to hire you. Okay. So here is how it works. These are called bridge petitions. Bridge petitions. Okay. When you go from 1 to 2 to 3, between 1 and 2, 2's application is the bridge. Between 2 and 3, 3's application is 2's application is the bridge. Okay. So the idea is you are going from 1 to 2 to 3. If 2 is not yet approved and you file through 3, you will get approval of 3 within USA only if 2 is approved first. Otherwise, you can file, and if 2 is either revoked or withdrawn, you can always go get a visa stamp and come back. No big deal. Can they do it? Sure. Could there be some additional running around? Sure, why not? Not the end of the world. Okay. Make sense or no?
So you're saying even if the second petition gets revoked or something, the third one could get approved.
Absolutely.
It will not make any problem to third one.
Absolutely. Approval does not depend upon anything. But approval within USA with an I-94 depends upon 2 getting approved.
Okay. And just one last question is so you said the 2 would get approved first and then the third one, but without the approval, I would still be able to start my job, right?
Yes.
The third one.
Yes. So the way it works is, this is very clear. There is no ambiguity in the law here. If you filed the second H1B going from 1 to 2 within the life of the first H1B or within 60 days following the layoff, you can actually join employer number 2 right away. Okay. When 2's case is still pending and you go to 3, you can join 3 right away. No problem with that.
Okay. And for the third one, the petition, basically the previous, they would need the previous petition number, receipt number, or the petition, the I-7979C, for the new petition.
Yes.
Will they need it?
Yes. They'll need a copy of the receipt as well as the copy of the approval from the first petition.
The first, okay, got it, okay. Thank you, I'm clear now. Thank you so much.
You're welcome. Good luck. I'm going to Maryland and then to India. Okay, bye, Kartika. Going to Maryland, then to India. Let's go to Maryland. 301, go ahead, please. 301.
Can you hear me?
Yeah, 301, I can hear you.
Yes, hi. Thank you for taking this. This is regarding my parents for the re-entry permit. So they are in India right now. They were here last year in September, and then they left for India. So their re-entry permit, the letter they received that it's still in processing. It will take them 17 months. But so they're still in India, and but the re-entry, they have green card also, and the re-entry permit said it's going to expire in November.
Okay.
But it's saying it's still processing. So do they have to come back right away, or can they come next year?
Well, I am not sure I follow your entire narrative. So first of all, let me try to understand what you are saying. Your parents have a green card. They applied for re-entry permit and went to India. Okay, so far this is what happened? Is this what happened?
Correct.
Okay.
Yes.
So they have been in India for 17 months, you said?
No. They were here last year, and they left. They were here in July last year, and then they went back to India in November last year.
Okay. So,
of 2022.
So how long has the re-entry permit been pending, and how long have they been in India now?
So now, in this November, it will be a year since they have been in India.
Okay. So here is my concern. If my client is in a situation where the re-entry permit is pending and they are absent or going to be absent for a year, I tell them to come back before the year is over. Okay, because I don't want to take the chance something goes wrong with the re-entry permit and then all of a sudden they've lost their green card. At least there is some argument there. Okay, so my advice, bring them back. Okay, even if they come back for a week and then go back again, I think it's okay.
I see. But they have to be back before.
They don't have to be. That is simply the cautious lawyer in me that says, let's not take a chance with this.
Okay. I see. Okay. All right.
Good luck, ma'am.
Sounds good.
All right. Bye-bye.
Thank you again.
You're welcome.
Bye.
Yeah, India, go ahead. After India, I have 2 New Jersey calls, then we are done. Next is 848, then there is 732. Let's go to India first. India, go ahead, please. India.
Hi, Rajiv. Am I audible?
Yes, perfectly.
Yeah. Thank you for taking my call.
Sure.
My question is, I have a approved I-140, which I recently got to know through FOIA.
Okay.
And priority date was in the year 2007.
Okay.
And when I checked my, this I-140, in the visa number through NBC, they told me that this has been terminated, and now it's been more than 2 years. We waited for you, and it has been terminated. Whereas I haven't got any letter from them.
Okay.
Now my question is, can a new employer file a new petition and use the same, retain or recapture the same priority date from the terminated one?
Okay, there are too many ifs and buts here. I don't know all the facts. First of all, you said the revocation occurred only 2 years back?
Yes, the I-140, yeah. So
Okay.
NBC is telling me that, it has been terminated. They waited for 2 years. The grace period is over. It has become current in 2021.
Okay.
And after that, they waited, and now...
No. That is not legal. They cannot do that. I don't understand. That you're getting wrong information.
I see.
There is no such rule. Okay? So that is wrong information. And if they have terminated it, you should file a lawsuit against them. This makes no sense.
All right. So, and I have got a new employer, but can they file a new petition and use the same, retain the same, recapture the same TD from the old petition?
So first of all, they'll have to start from the PERM, that you know, right? They'll have to start from the ground up.
Yes.
Now, the priority date usage depends upon this. If the case was revoked after January 17, 2017, yes, you should be able to keep the priority date. Now, why was the case revoked? They kept it pending. That is nonsense. I-140 once approved is good forever. Forever and ever and ever. Okay. So, if it is revoked for something like fraud or misrepresentation, then you don't get priority date. So I just don't have enough facts here. So what you may want to do is get together with the employer who did the I-140, find out what exactly happened, talk to their lawyers. If the case was revoked by the USCIS, you should sue them.
All right. No, they mentioned a section of INA 203G. Under that, they have terminated.
No, INA 203B. INA 203B is simply the section that gives you EB2 category. So I have no idea what
203B.
Yeah, I'm looking at 203B. Allocation of immigrant visas. That simply says, let's see, allocation of 1150.
No, it's 203G, sir.
Oh, G as in girl. Okay. So
G as in G as in Gandhi.
G as in girl, right?
Girl, that's right.
Okay. Termination of any within 1 year following. Also, they did you know they must have filed this case through consular processing. Okay, so there is a provision. INA 203G says, if we inform you that your visa is available, you have to contact us within 1 year. If you don't contact us, we will terminate it.
Right.
Okay. So see what happened was your lawyers filed the case as visa processing instead of adjustment of status. So the case went to India, and India said, we'll hold the case. They tried to inform you and that you didn't contact them for 1 year. First thing you should do is contact the consulate in India, see if they can revive the case. Explain to them what happened and why you couldn't contact, whatever the reasons are. So try doing that. Okay, I gotta take my last 2 calls, but don't give up on this. Follow it through. There might be a way to revive this. Okay.
Right. Now, sir, can I ask one more? Like there is a new employer. Now can they find a new petition with a new employer and use the same priority date?
That's what I just told you that. I said if this case was revoked, you may not be able to use the priority date. So normally, if it was not revoked, definitely. So there's a whole lot I don't understand here. I've got to know more about it. Talk to your new lawyers. Tell them where the situation is. They should be able to find out. I gotta go. Okay. Good luck. Area code 848. Go ahead, please.
Hi, Rajiv. I have a question on behalf of my dad, and he's sitting right next to me. So a little bit of a high level of his case. He came to the United States on an approved L1A visa in 2015.
Okay.
And then in 2016, he got his extension of the L1A approved.
Okay.
And in 2017, he filed for an I-140.
Okay.
And in 2019, that I-140 got rejected.
Okay.
And in the March of 2019, he filed for something called I-290B, which is motion to reconsider.
Sure.
And he hasn't heard from USCIS till date. He has raised 4 or 5 service requests, and they just keep telling him that, hey, contact, we'll get back to you in 60 days, but they haven't gotten back to us yet. So his question is, what should he do?
Okay, so just again, very quickly, without knowing all the facts, I can tell you this. It appears to me that he is accruing unlawful presence, which means he has been unlawfully present now for over 1 year. Just because
he's actually in India. He's not in the States.
Then there is no issue. He can always refile the L1. I mean, if the companies are still operational, he can just refile the L1.
So he actually did, and for some reason that L1 got rejected. He did file it a year ago, and it got rejected for some reason.
Well, we would need to know why it got rejected. Because
he filed the first one.
Yeah, cases don't get rejected. They have to give you a detailed reason why they're rejecting the case. Okay. So what I would...
It got rejected because of a...
Go ahead.
Yeah, go ahead.
No, you said it got rejected because...
So it got rejected, the new L1... Yeah, the new L1 that he filed a year ago, that got rejected because of his managerial role. They brought up something and they rejected it.
Okay. So yeah, so obviously you know. Hang on. Hang on. So you obviously know what the reasons are. Get yourself a lawyer who can review the situation, show you the way out. If there is a way out, there may not be one. This is not a complicated situation. It's a very straightforward situation. See, let me guess. I'm guessing.
So
I'm guessing your father's business is a small business, correct?
Yes, it is a small business. He actually owns that business and he filed L1 on his own company.
Small businesses have devil of a time getting L1 approvals. So I have to take my last call. I've got to go. This is not something I can discuss in the abstract. I would recommend either setting up a consultation with us or talking with your lawyers who are doing the L1. They should be able to advise you. This is not complicated. This is straightforward. Okay.
Understood. Do you recommend suing USCIS or no?
Oh, God, no. Absolutely not. Such a waste of money. I would have to see what the reasons are, but they have a lot of discretion in these denials. And for smaller businesses, this is discretion galore. They can do a lot of things that they can get away with. So it'll be, personally, again, I don't know the whole case. My first instinct is to say, no. Look at the case, if it can be salvaged somewhere with just transactional work rather than litigation. That's the way to go. But no harm in getting an opinion from a litigator. You can, if you want. Okay?
Understood. We'll file a consultation with you. We'll take it from there.
No worries. Good luck. Area code 732, last question of the day. Go ahead, please.
Yeah. Hi, sir. Rajiv, sir. Good afternoon. How are you?
Don't call me sir. I am good. How are you doing?
Thanks. All good. I have a quick question regarding the, I have chatted earlier you on the LinkedIn messages. So this is like, I have received an RFE for the OPT initial to like proof me for the statement of the address. The only reason that I have given to the USCIS while submitting the form, the New Jersey address, the reason because I feel it more safer because it was my relative's address. And into the university, I have my Virginia Fairfax address. So I just wanted to know, is this why I have got the RFE?
Well, I don't know. I don't know
my proof of address.
I don't know the mind of the USCIS. All I can tell you is they send RFEs like this where they suspect that you are not really attending school. So if you can show that you've been attending school, you should be okay.
But all the classes were remote, so none were in the.
Well, that's not really legal. For the August session, that's not really legal. Okay.
Okay.
You can only have I think one course online. Everything else has to be on campus. So post-COVID, this all changed. So I don't know how the university is allowing you to take all classes online. You can't maintain F1 status through all remote classes.
Okay.
Get together
and if my transcript address.
Yeah, get together with your DSO, figure it out, because this doesn't make any sense to me. How are they giving you all online classes? They should have told you not to.
Okay, I see.
Okay,
so probably I need to reach out to the DSO.
Reach out to the DSO and ask them this specifically, that as far as I understand, that this session you can't do all remote classes, number one. Number two, ask them, do I have to apply for reinstatement now? Am I out of status? Okay.
Okay. Yeah.
So that's what you need to do.
Thank you, sir.
You're welcome. By the way, never ever give an address where you don't live. That's not a good idea. Going forward.
I see. Yeah, that's the biggest mistake.
Yeah, don't worry. Going forward.
Thanks. That's what I was assuming. But I was not living there in New Jersey and I gave that address. I thought I made a mistake.
Yeah, that's okay. Let's just figure out whether you are in status or not. That's the most important thing. Okay.
Yeah, I'll reach out to the DSO.
Yes, ma'am.
Definitely.
Very best of luck to you. Okay.
Yeah.
All right. Bye-bye.
Thank you, sir.
Bye.
Bye.
All right, folks. Great talking to all of you and hanging out. See you next Thursday on LinkedIn. Take care, everyone.